Final case up for argument today is the Board of Trustees of the City of Pontiac Police and Fire Retiree Health Insurance Trust versus the City of Pontiac. Good afternoon.
Good afternoon. Steve Hitchcock. I'm appearing on behalf of the City of Pontiac, which is defendant appellant, and this time around at least. This case, as you know, has been before you once before, and it's been in the Court of Appeals and back before. To address the specific questions that you raised, first being that did the Court of Appeals correctly conclude that the principles of LaFontaine apply to the EM order in this case? We get no direction from the Court of Appeals on what their thinking was, because they basically said there was no case law on whether EM executive order should be considered a statute, and then they didn't even provide any analysis and just said that they think it's appropriate, that it should be considered to be legislative. I would disagree with that, and I think this court should also, that in fact the administrative order of the EM is not a statute. He's carrying out authority that's granted to him under a statute, and in this case it applies to only one contractual relationship, which is very different from the reasons for the LaFontaine case and the tests that are in that case when you're dealing with legislation that has a broad-based effect upon citizens. In this case, this is just one contract that was affected, and in fact it didn't deprive any of the retirees of any benefits under that contract or any vested rights. This was a fund, a VIVA fund, that had $40 million in it at the time the EM directed this order. And
didn't they have a right to sue once the money became due and wasn't paid? Isn't that a vested right?
Well, that's a contractual right, yes, but I don't think it rises from a legislative action.
Well, you just said the rights, that they didn't have any vested rights. Seems
well,
to me when you're owed money and it's not paid.
The individual participants certainly didn't have any vested rights that were damaged by this, because
no, but they're not. The individuals aren't suing. The fund is suing.
And the fund, it had a breach of contract action.
Yeah, cause of action. That's a vested right, right?
Well, not in the sense that I don't think that the legislature and the LaFontaine case are intended to apply to legislation.
Let me ask you this. If we go along with your formulation, doesn't that just create an exception or a way around the constitutional protections with respect to retroactivity? So you couldn't do it if by legislation, but if by legislation you told somebody else to do it, you're okay?
Well, they could have, but didn't attack the legislation itself and say the Public Act 4, which allowed an emergency manager to take actions with regards to existing contracts, was unconstitutional in and of itself, because it would be impairing contractual rights. And then you could have had a claim that way, but I think when you don't make the claim with regards to the statute itself, there's all kinds of executive decisions that are made by everybody from the governor down through other positions, I guess, relying upon statutes. So I think
I would your argument. Did they have to make the challenge to the statute before the emergency manager issued the order, or you're saying after the order was issued? Or I mean, they're obviously focusing on the action that was taken against them, right?
Right, and I think, as I say, I think that's a breach of contract action, and you should use normal contract construction to try to decide whether or not, in fact, the EM's order had a retroactive effect or not, and normal contract construction on that. And you've already decided that. I think last time you indicated in the order then that you thought the EM did intend it to be retroactive, and the language supported his making it retroactive. So an interpretation from a contractual point of view.
I think the problem with that argument is if we decided it already, there would have been no reason to send it back. So I think a better interpretation of our order is that we decided that the language was broad enough to encompass those retroactive payments, and then we sent it back for the more searching inquiry that's required under retroactivity law.
Well, and even if you say LaFontaine applies, I think the very first test is complied with here. If you read the language of his order and read what this court said before, that his order is clear that he intended it to be retroactive, applies to any obligations they had to make payments, and this certainly was an obligation at the time he passed the order. Whether it's a delinquent obligation or a current obligation, it's still an obligation to pay. And effectively what his order was doing is kicking the can down the road, because it doesn't change the unfunded liability to this VIVA that eventually gets paid, but it affects the cash flow to the VIVA, or in this case, the cash flow out of the city too, which was the more important issue.
You say it
at the
doesn't
time.
affect the unfunded liability. Doesn't it decrease the unfunded liability if they make the payment?
No, it doesn't. Well, no, it didn't decrease it. But the unfunded liability, in other words, the obligation to pay the unfunded liability still exists for the city, whether you pay it in year 2012 or you pay it in year 2013 or subsequent years. That obligation is not changed by his order that says we're not going to make this payment at this point in time. So I think, again, that's different from legislative actions which have a permanent effect upon the citizens that it affects.
Isn't there a higher standard for retroactivity? If you're going to allow for something to be retroactive, doesn't that require a higher standard?
Well, I think as far as legislation, LaFontaine suggests there's a higher standard because of the fact that it has this permanent long-term effect. But I'm suggesting to you that in this particular case, the EM's executive order shouldn't be considered the same as legislation and shouldn't be held to that higher test. But I also believe that if you look at the first test of LaFontaine, it's whether or not there's a clear expression of an intent to make it retroactive, and to the extent that that payment was due on June 30th, and it was August 1st when he entered his order, and based on the language of his order, he clearly had an intent that it would apply to the June 2012 payment also.
Isn't that something that the court, because of the standard, isn't that something that when you're dealing with retroactivity, isn't that something that should always give pause or caution to this court?
I think you should have pause and caution when it's a legislative action by the legislature, yes. And if the question that was before you was whether Public Act 4, at least its provisions that allowed an emergency manager to go down this path and do these things could be retroactive, then you would have clearly a legislative action and clearly the LaFontaine test would apply. They did not attack the statute. I also want, unless there's any questions more questions on that, I want to address also the constitutional provision that you placed in your order. Back in the early 60s, when this Constitution was put in place, this constitutional provision, there was no health care for public employees. And as you've already said in the Studer decision, when I would ask that you continue to uphold that decision, that the legislature, or I guess it would be the Charter Commission, did not intend that this provision would also apply to health care.
But Counsel, I have a question. So in following your argument, if health care doesn't have a financial interest, if it's not a financial interest, how would you then equate it, or how would you then define it?
Well, it doesn't have an accrued financial benefit
Right.
that is defined in the statute. I think it's,
How could it not, though? I mean, I guess that's where I'd like you to explain, like how, if you're talking about an accrued financial, what would you define healthcare as if it isn't an accrued financial benefit?
well, you can't measure it like you can a pension benefit.
Why?
Which is a mathematical calculation. Because, one, the benefits are constantly in motion and changing on healthcare.
Okay.
So, two, the plans are constantly changing in motion, and insurance coverage is constantly changing.
But if I'm Counsel, if I'm negotiating and I'm entering into a vested contract, there's a value of the health care that's being entered and put forth in that contract, is it not? I mean, part of collective bargaining is that you negotiate for health care, and when you're negotiating for health care, there is a value that's assigned to that as it pertains to the worth of the contract.
And that's a contractual arrangement, and my suggestion to you is that's where it should be left, and that's the proper place for any enforcement, is whether or not, what is the language of any contractual relationship between the employees and the employer, and what does it say with regards to health care, and not try to go back now and fit some language that was adopted in the early 60s without any intent with regards to retiree health care.
But I still don't understand, though, because, okay, so I understand what you're talking about as it pertains to the contractual law basis, but what I'm trying to understand is basically the conceptual understanding of the product of health care not having a financial interest. That's where I'm kind of lost as to the fact that your argument seems to be that health care doesn't have a financial basis or financial interest, and what I'm saying is that if healthcare doesn't have a financial interest, how would you then assign it, or how would you equate healthcare as a value?
No, I'm saying that in terms of the language that's used in the Constitution, it doesn't have an accrued financial benefit as that language is used in the constitutional provision, and you're going to open up a can of worms trying to figure out what does that language mean with respect to health care, and how would you calculate in any situation that moving target of what the costs are that you're going to try to hold an employer to contributing, I guess, under this language. And and I'm pretty sure that if there was a constitutional commission right now trying to develop a new constitution and they wanted to address health care, they would use much different language than is in this constitutional provision, Article 9, Section 24. And you've already addressed it in the Studer decision, and everybody in the world has gone out and relied upon the Studer decision in developing their contractual relationships and language with regards to health care, and to try to go back and now retrofit healthcare into this language when it wasn't intended is going to create a lot of needless litigation, when in fact in the world the employers and employees are dealing with that through collective bargaining agreements. I would urge you to not overturn the Studer decision.
Any other questions? Thank you very much. Your case will be submitted.
Oh, do you want to give the other guy a chance to argue?
Oh, sorry.
We're very efficient.
I thought you were already up on, yeah, I'm sorry.
I try to be discreet. But
I'm trying to be efficient, and
You were just that
too efficient today.
You were just that good.
I'm a rookie, keep in mind. This is my first time in the middle chair.
yeah, they're non-visibly good. I think that the most controlling point in this appeal is whether or not the executive order that was issued by the emergency manager is to be construed under the same standards of interpretation, including the standards of retroactivity that are subject or that are applicable to statutes to the state legislature. In our briefs, and in the Michigan Court of Appeals on remand, it has been made abundantly clear that executive orders from emergency managers are at a minimum quasi-legislative in nature, because they are, the executive managers are acting upon authority granted to them by the legislature, and as such, those orders, just as administrative regulations that are issued by agencies, are subject to the same standards of interpretation under LaFontaine as are statutes. The defendant's assertion that the Court of Appeals did not offer an analysis on this point is just blatantly wrong. The Court of Appeals, in fact, specifically cited to the Supreme Court case that controlled its analysis, the soap and detergent case, which held that executive orders are, like administrative regulations, sufficiently legislative in nature as to be subject to the same set of interpretation standards as administrative decisions, administrative regulations, and the state legislature. I also want to reemphasize a case that was cited in our supplemental brief by the United States Court of Appeals for the Sixth Circuit.
Can I ask, isn't it two different issues, though? The fact that executive orders are interpreted the same way as statutes, no one really disputes that. All written materials, contracts, statutes, administrative law, executive orders, we look to the words of the statutes. We interpret them by the same set of interpretive tools. But does that necessarily mean, though, that the rule of retroactivity to statutes applies the same to an executive order issued by an emergency manager when the legislature gave the emergency manager broad discretion and authority? Why does the fact that we interpret words by the same set of rules necessarily lead to the conclusion that a retroactivity analysis must also apply?
The retroactivity analysis is considered a standard of interpretation of statutes. It comes within that subset of interpretative.
Is there a canon of interpretation that relates to retroactivity?
The canon of interpretation would be the standards that are set forth in LaFontaine, yes. And then those canons begin with the requirement that in order for a statute to be considered to be retroactive, the statute must specifically state so.
Well, LaFontaine does not tell me what the statute means. It tells me when it applies. Rules of interpretation tells me what something means. We use rules of interpretation to understand the words. We have a different question here. Whether those words should apply to something after the fact is the question. And so I'm not following why rules of interpretation include rules of retroactivity.
Because rules of retroactivity are considered to be part and parcel of the language of the statute. And if the statute does not specifically say within the terms of the statute that the dictates of the statute are going to be applied retroactively, then it is determined as a matter of law and as a matter of interpretation that the statute will only be applied prospectively. I guess I do disagree.
So taking that rule, then, why can the emergency manager avoid any portion of the contract? The contract existed before the emergency manager existed. Wouldn't it be retroactive to change the terms of the contract?
In order for the emergency manager to successfully attempt to try to change the terms of the contract retroactively, in order to eliminate an already accrued right that was obtained through that contract, the order of the emergency manager must specifically state that the directive is being applied retroactively to the pre-existing accrued rights, to take away the pre-existing.
And what makes it accrued right? The ability to sue?
Yes. The ability to sue for breach of contract. The right became due under the underlying contract. Yes.
All right.
I wanted to go back to Welch versus Brown on the threshold issue of whether or not orders of an emergency manager are sufficiently legislative in nature so as to apply to LaFontaine or be applicable under the standards of LaFontaine. And in Welch v. Brown, the U.S. Court of Appeals for the Sixth Circuit specifically said that the emergency manager's powers to abrogate a collective bargaining agreement, that those specific powers in and of themselves are legislative in nature because those powers are derived by grant of authority by the legislature, and those are, in fact, the sovereign powers to appropriate funds back to the government. Again, the Welch versus Brown case was cited in our supplemental brief. We think that it's directly on point and instructive on the threshold issue.
But again, going back to what Justice Zarr was asking, doesn't the fact that the emergency manager has the power to abrogate contracts automatically suggest a form of retroactivity? If you're abrogating contracts, you're dealing with something that was set in stone before, and you're saying going forward it's null and void.
I think that presuming that the emergency manager has the statutory power to nullify contracts, if you presume that to be true, the order of the emergency manager must still specifically state that the elimination of the contractual duty retroactively was in fact retroactive. The order must specifically state that the directive is being applied retroactively to accrued rights that have accrued because of delinquent contributions. So the answer to your question is that presuming that the emergency manager has the statutory right to abrogate contractual duties under collective bargaining agreement, that right will be construed to have been invoked prospectively unless the directive from the emergency manager specifically states that it is to be applied retroactively to accrued rights. Now, the emergency manager's order was not so specific. And instead, the emergency manager's order only said that it is abrogating the duty to continue to make contributions and that the order shall take effect immediately. We know from LaFontaine that when an order is taking effect or is going to have an effective date of immediately, that means that the order is prospective only and is not intended as a substitution for specific language saying specifically that the order is intended to apply retroactively. Going a little bit beyond, I think, your question with respect to the power of the emergency manager, I do think that in light of the LaFontaine analysis and in light of the prescription, the prohibition in LaFontaine of permitting a statute to retroactively eliminate accrued rights, in light of that prohibition, I got a major problem with the validity of the position that the emergency manager had the right to eliminate retroactively accrued rights, even if he specifically said he was doing so, which he didn't do in this case. Even if he specifically said he was doing so, I think that that violates the prescription of LaFontaine and its predecessors, which do not permit legislation and, by extension, administrative regulations and executive orders. They do not permit these directives from the government to apply retroactively if the result is to eliminate accrued vested rights. I think that that's illegal. On the issue of illegality, the last part of the Supreme Court's order directed the parties to brief the applicability of Article 9, Section 24. I do think that the emergency manager's order in addition, violated this this constitutional provision. As Justice Bernstein indicated in his questioning to opposing counsel, I think that the Studier decision erroneously held that retirement health benefits are not accrued financial benefits that are subject to this constitutional provision. I don't know any other way how you can say that health benefits that are already due and owing are not accrued, number one, and they're not financial.
Would that give rise to a cause of action for every person who's on a state pension plan, whose pension amount is based upon their departing salary, to claim, well, you owe me back pay because that included my health care benefits, which you didn't include?
To the extent that a statute or an executive order takes away benefits that have been bargained for and that are due and owing, then that directive is unconstitutional under Article 9, Section 24. So if anybody has had those benefits which were accrued, then taken away, that would be constitutionally infirm.
But what you're telling me, Studier is wrong, because when they said financial benefits don't include health care benefits, it is in fact a financial benefit.
It is a financial benefit, yes. And we are requesting in the alternative that the court overturn Studier and adopt the dissenting opinion in that case.
How do you calculate it?
I'm sorry?
How do you calculate the financial part of the benefit? Is it premiums? Is it some other?
It's the overdue contributions that are owing already. In this case, $3.475 million overdue under the existing contract. Does the court have any other questions?
Are you familiar with Robinson versus City of Detroit and the stare decisis analysis as to when we should reverse prior to decisions of our court, even if we conclude that they were wrongly decided?
I think that that decision has to be subject to the authority which we cited in our brief, that when it comes especially to constitutional interests, that you need to give a greater scrutiny.
All right, you do have some time left for rebuttal before we submit your case. Would you like to use it?
I just want to say one thing. Whether counsel seems to be trying to argue to you that unless the words retroactive are specifically used, that it can't be retroactive. And I would submit to you that that's not the test, even if you applied the LaFontaine case. It doesn't say you have to use the words retroactive in your language to get it retroactive. You have to look at the intent of the drafter and what they were doing. So I concede that the emergency manager didn't use the word retroactive in his language, but I don't think that that's controlling as to whether or not the effect of what his order was could be retroactive.
Okay, thank you. Any other questions? We will now submit your case. Thank you very much. We'll adjourn until tomorrow.
Submit it again.